Hello, everyone. My name is Oscar Michelen, and I'm a partner in the law firm of Cuomo, LLC in Michelen, and a vice president of the Long Island Hispanic Bar Association. This short video answers some of the most common questions that employers and employees have about COVID-19 in the workplace. It is for informational purposes only and does not constitute legal advice, nor does it form an attorney-client relationship. We have about 8 quick points that we'll just go through. Number 1, employers can and should require an employee who becomes ill with COVID-19 to notify their supervisor. Employees who are suffering from COVID-19 should be directed to remain at home until they are symptom-free for at least 14 days. While outside of work, if an employee begins experiencing symptoms, has been exposed to someone that is exhibiting symptoms, or has tested positive, the employee should contact the company by telephone or email and should not report to work. Number 2, employers are permitted to ask employees to seek medical attention and get tested for COVID-19. Advising workers to stay home is permissible by law. Number 3, an employer may measure an employee's body temperature under current circumstances here due to the pandemic. 4, an employer can and should send home all employees who worked closely with an infected employee. Before the infected employee departs, ask them to identify all individuals who worked in close proximity within 6 feet for a prolonged period of time, 10 to 15 minutes or more, with them during the 48-hour period before the onset of symptoms to ensure you have a full list of those who should be sent home. When sending the employees home, do not identify by name the infected employee, or you could risk a violation of confidentiality laws. Employees cannot refuse to work for fear of catching COVID-19. They are only entitled to refuse to work if they believe they are in imminent danger. An imminent danger is one which can reasonably be expected to cause death or serious physical injury immediately. The threat must be greater than the threat in the general public. Number 6, employers should provide masks for workers, and if mandatory in the workplace, workers cannot refuse to wear masks. Number 7, though well-intentioned, employers should not operate child care centers which require proper licensing from the state. Unless you already have or can obtain a daycare license, you should refrain from operating a daycare center in your workplace. Similarly, you should refrain from offering informal entertainment areas or kids zones because state regulating agencies may consider them unlicensed daycare centers. 8, final question. If an employee gets COVID-19 from the workplace, will they have a workers' compensation claim? Well, if the employee is a healthcare worker or a first responder, the answer is likely yes. But for other workers, the virus is not an injury, but instead it's analyzed under state law to determine whether it's an occupational disease. To be an occupational disease, an employee must generally show 2 things. 1 is that the illness must arise out of and was in the course of employment, and 2, that the illness arises out of or is caused by conditions peculiar to the work or the workplace and creates a risk of contracting the disease in a greater degree or in a different manner than the public generally. So I hope you found this video informative. You can find more information about the law on COVID-19 at LIH's website, lihba.org. And I thank you very much for watching. Stay safe.